The National Labor Relations Board was created by Congress to serve as a fair and neutral mediator to help resolve workplace disputes between employers and employees. The Biden administration has used the NLRB as a tool instead of for employees for big labor interests. In May of 2023, the NLRB issued a decision in the Lyon Elastomers LLC case that restores the board's setting specific standard for determining whether an employee's abusive conduct is protected by the NLRA. The decision will make it very difficult to discipline workers for offensive or abusive conduct while engaging in quote-unquote protected activity under the NLRA. The board held that to fully protect employee rights, conduct during protected concerted activity must be evaluated in the context of that important activity, not as if it occurred in the ordinary workplace context. Marvin Kaplan dissented from the decision, highlighting that it would create significant conflict between the board law and equal opportunity laws prohibiting discrimination, workforce, and harassment issues. So my first question is for Mr. Ring. As being the former chairman of the NLRB, I understand that you formerly served, and so you might have some insight on the decision, the Lyon Elastomers case, which would, I believe, create potentially opportunities for people to make racially offensive, discriminatory, or sexually offensive statements or otherwise at work without repercussion. Can you discuss how this creates a direct conflict between the NLRA and Title VII of the Human Rights Act, Civil Rights Act?
Yes, thank you, Congressman. The NLRA, or the NLRB, for some reason, as you mentioned, believes that employees who engage in union activity or other kind of labor relations activity have to use, or should be permitted to use, offensive conduct and offensive speech. When I was chairman, we overturned those setting specific standards in a case called General Motors, and then the current board reversed again and reinstated Lyon Elastomers. Under our civil rights laws, and the EOC has weighed in on this, employers are required to take action when employees are engaging in offensive conduct that could create a hostile work environment. The NLRB then takes the position that that is protected. So it puts employers in the position of having to decide whether to violate the civil rights laws or the EEO laws, or a violation of the National Labor Relations Act. And you know, the conduct that was permitted under this standard is abhorrent.
So in essence, you can be racially, you can discriminate, you can be offensive, you can commit sexual harassment, so long as you are organizing.
Or worse than that, as long as you are mentioning wages, hours, or working conditions while you're talking about that.
Thank you. Mr. Seaton, the NLRB issued decisions to limit the circumstances and times when employees can decertify or change union representation. Can you discuss how this has made it more difficult for workers and eliminated their choice whether or not to withdraw from a union?
Yes, thank you, Mr. Chairman. Yes, a core principle, of course, as everyone at the table has said before the committee, is employee choice. Part of the choice is a choice to end union representation, and that's the decertification election process. That process has been truncated under the current board chair so that in prior circumstances where this had been available at the sale of a business in many cases, at the termination of a collective bargaining agreement, in an impasse situation, or simply when the employees chose to do so, when a contract wasn't in effect, the board has truncated this right and has typically undermined the decision the employees have made in many of these instances, saying that somehow the employer is always involved somehow when a decertification takes place. And I think this is a fundamental trampling on the rights of employees to make these choices, and it has been a serious problem under this current chair.
I believe that employees should have the choice to remain in the union or negotiate with their employer without a union representation, which is why I introduced the Workers' Choice Act.